Okay, welcome to class 4 of intellectual property, in which we're going to be discussing the requirement that in order to successfully assert trade secret protection, you have to show not only that you actually have secret information, but also that you have successfully or reasonably maintained secrecy, or rather reasonably maintained secrecy of the information in question. So as you'll recall, in order to have a trade secret in the first place under the Uniform Trade Secret Act, and broadly speaking under state trade secret law too, although the requirements of state law at least are slightly different in some cases, generally not significantly so, but the requirements can vary slightly from state to state, potentially having effects, although frequently not having effects on trade secret protection. In any case, the first requirement, of course, is the claimant of trade secret protection has to show that the information is in question is actually secret and not readily obtainable by proper means by third parties. In other words, it's secret information that people couldn't figure out just by trying if they wanted to, that it's actually something that could be a real legitimate secret. And then second, and this is a requirement we're going to talk about in this class, the claimant of the trade secret has to show that they actually invested reasonable efforts in maintaining the secrecy of the information in question. Now, of course, what constitutes reasonable efforts is going to be a fact-dependent question, presumably impacted by the level of innate secrecy of the information in question. Okay, so several different cases sort of illustrating how this works in practice. An older case from 1991, in an opinion decided by Judge Posner, Rockwell v. DEV. What happened here? Well, Rockwell is in the business of making printing presses and parts for printing presses. And one essential element of their business, specifically the element of their business that involves making parts for printing presses, are what are known as these essential piece part drawings, right? So piece part drawings are needed in order to make the replacement parts for printing presses. Some of these replacement parts are made by Rockwell itself, but others are made by vendors. And so in order for those vendors to be able to make the piece part replacements, Rockwell has to send them the piece part drawings, which are critical to making the parts themselves. And Rockwell contends that without the piece part drawings, it is effectively impossible to make replacement parts that would actually function, that you couldn't in fact reverse engineer the piece parts from the parts themselves, because what matters isn't just the shape of the parts, but actually the way in which they're made, the nature of the alloys, the manufacturing process, so on and so forth. So these piece part drawings are essential to the manufacture of these replacement parts, and Rockwell is sending some of these piece part drawings to vendors. Now, what's the problem here? Of course, as is so often the case, former Rockwell employees have joined a Rockwell competitor in the piece part business named DEV, one of them leaving Rockwell to become the president of DEV, the other one getting fired by Rockwell when a Rockwell employee, I believe a janitor, found this employee attempting to steal piece part drawings from Rockwell and subsequently joined DEV, working for them instead. So Rockwell brought the action against DEV, and it came to light that DEV was in possession of a very large number, about 700 piece part drawings from different companies. So it was making parts for machines made by lots of different companies, about 100 of which were Rockwell piece part drawings. And so Rockwell's argument was, well, these are trade secrets, that they're valuable because they're secret, and we only give them to vendors who we trust to maintain that secrecy, and therefore you have infringed trade secret protection by pilfering them from us. DEV's response is, look, you didn't use enough effort to maintain the secrecy of these drawings. Yes, you do require confidentiality, but you also send them out to vendors, and you even let vendors make copies of these piece part drawings, as well as other kinds of drawings that are relevant to the machines in question. And you shouldn't be able to assert trade secret protection under the circumstances because the efforts you expended in maintaining secrecy were insufficient. So the district court found DEV's defense compelling under the circumstances. Ultimately, the Seventh Circuit, in this opinion by Judge Posner, reverses in large part because Posner says, look, we can't know what was reasonable under the circumstances because that's a fundamentally fact-specific question. In other words, we have to ask, what do we think is reasonable and what did Rockwell do and why under the circumstances? In other words, what's the definition of reasonable in relation to the piece part drawings in question in the particular industry? That's a question of fact to be litigated, not something to be decided on summary judgment. In addition, interestingly, Posner kind of poses the question of what are we doing trade secret protection for in the first place? In other words, are we trying to punish improper behavior on the part of the defendant? In other words, are we trying to stop DEV and companies like DEV from misappropriating trade secret information? Or are we trying to incentivize investment in the production and creation of trade secrets? And depending on which of those two goals or how we weight those two different goals, how might that affect our analysis of the trade secret infringement analysis, and specifically what constitutes reasonable efforts to maintain secrecy in relation to a particular secret? Okay. So moving on to discuss in a subsequent case in Mason v. AmTrust Financial Services, Mason develops a pricing tool and shares it with the employer, his subsequent employer, AmTrust. He contends that this pricing tool is what essentially encouraged AmTrust to hire him in the first place. And this pricing tool was used by Mason and other AmTrust employees during Mason's employment at AmTrust. When Mason is ultimately fired by AmTrust, he brings an action against them, asking the court to enjoin AmTrust from continuing to use the pricing tool. And the district court dismisses the action, essentially because there's no written agreement between Mason and AmTrust about the pricing tool, or how it's going to be used and who's going to be in control of it. Mason says, well, we had an implicit agreement, and it was kind of baked into the nature of a relationship. The district court doesn't think that's sufficient, and the Second Circuit essentially agrees. Okay, in another case, IntelliClear v. ETC. So what happened here was IntelliClear has essentially a computer system that they developed for managing the different aspects of a stock brokerage firm, kind of soup to nuts software tool for managing the back office of a brokerage firm. ETC licenses this system from IntelliClear, uses it for about 10 years, and uses it subsequent to a explicitly confidential licensing agreement. Okay, so after about 10 years, ETC decides to terminate the licensing agreement with IntelliClear. And in the intervening period of time, it has in fact developed its own management system for its business, which it begins to use. And it turns out that its system is, lo and behold, very similar to the IntelliClear system. And IntelliClear brings a trade secret action against ETC, saying you've misappropriated trade secrets in violation of the confidentiality provisions of the licensing agreement that you signed with us, and brings on experts who compare the two systems and point to a bunch of similarities between the IntelliClear and ETC system. So ETC's defense is fundamentally that IntelliClear failed to properly identify what was actually secret about the management system in question. In other words, it says, look, IntelliClear, you just pointed to the system as a whole and said various aspects of the system are protectable and unique, but you didn't really point to what specific parts were protectable as trade secrets and why. And so the question is, did it do so sufficiently for the purpose of surviving summary judgment? And the Ninth Circuit ultimately says yes. Well, why is that? It says, look, basically anything can be a trade secret so long as it satisfies the criteria of being secret information is valuable because it's secret, that you invested reasonable efforts in maintaining the secrecy. And so, yes, IntelliClear has to identify which elements of its system were secret as opposed to being general knowledge within the field as a whole. But the Ninth Circuit thinks they've done that sufficiently for the purpose of summary judgment. Basically, they brought in experts, and the experts pointed to the particular aspects of the system that the experts believed were sufficiently unknown or sufficiently uncommon within the particular field in question, so as to qualify for trade secret protection. And they might be wrong, but that's at least enough to satisfy the requirements for summary judgment. They've essentially alleged with enough particularity that there is in fact trade secret information within the system in question. And in addition, they've also shown that even though some of this information might be common within the field, that they've at least alleged sufficiently that in combination with the various parts, that the elements were in fact unique or sufficiently unique that there could at least be one or more parts that would satisfy the requirement for trade secret protection, and also that those elements were not readily ascertainable, at least not readily ascertainable by anyone who wasn't also subject to the confidentiality provisions in question.